All right, good afternoon, everybody. My name is Nate Newberger. I'm a shareholder here in Reinhardt's corporate practice group. Do a lot of work on M&A transactions and leverage buyouts, and also just working with our business law clients as they go about their day-to-day business, buying and selling things, and just issues that come up as they operate their business. So today what I want to talk about is a few cases within the past year that have come up in the business law area. A lot of times I'll talk about Delaware cases. There's a plethora of business law cases that come out of Delaware, and they all sort of serve as cautionary tales, something that's gone awry in a transaction or a deal, and the parties to that transaction have ended up in court. So if you take a close look at some of these cases, it's a sort of a good instruction manual on how to not get into trouble. So I try to keep an eye on the cases going on in Delaware and find ones that relate to the types of transactions that I work on a day-to-day basis. Last year I gave a similar talk about some few Delaware cases, and one of the sort of pieces of feedback I got was, Delaware's really interesting, but a lot of us are here in Wisconsin. Are there any Wisconsin business law cases that might be a little bit more relevant to some of the things going on in our state? So this year I tried to look back and see, okay, what's been going on in Wisconsin the past year? Wisconsin doesn't get a ton of published business law cases, but I was able to find one that I actually thought was pretty interesting. I learned a few things as I looked into it a little bit more deeply. So we'll cover this Wisconsin law case, and then I've got a couple Delaware cases as well that we can work through in the next hour. So the first case is this Wisconsin case, and we need a little bit of background to really understand what the case involves. The case involves the fracking industry. Now, if you're like me, I had a sort of high-level understanding of what fracking is and how it relates to the world today, but not really a very in-depth knowledge of how fracking operates. So fracking at a very high level, it's a well stimulation technique. The energy companies devised ways to take the traditional oil wells, and they've sort of enhanced them using this fracking technique to allow them to access new areas of fossil fuels that weren't previously available to be accessed, and these are generally found in what are known as shale formations. And these shales are large geological structures that run across numerous states. For example, the Marcellus Shale on the eastern half of the United States, it runs through big chunks of Pennsylvania, Ohio, West Virginia. So there's very large geologic formations that previously energy companies weren't able to access, but now with fracking they're able to tap into these newfound sources. And then, as we all know, fracking is controversial. It's a source of energy, but it's also a source of potential problems. Just as an example, the chart there shows the area around Oklahoma City, which is in a fracking area, and over this 30-year period, it shows the number of seismic events that occurred in that area. And then the graph on the right shows over a 2-year period just the extreme proliferation of seismic events that have occurred, which many people attribute to the amount of fracking going on in the area. So even though it comes with its controversy, fracking undoubtedly has had a benefit on the U.S. economy. You can see over the past 6 years, as fracking has grown, the U.S. has become, in essence, energy independent, and also the leading producer of petroleum in the world. 2008, we were behind Russia, and not that far ahead of Saudi Arabia. But then, as you can see, by 2014, the U.S. has been leaps and bounds above the competition. And that corresponds to a significant growth in fracking over that same 6-year period. And most people really attribute the fact that we're the leading petroleum producer now to the fracking industry. So what exactly is fracking? Well, from the surface, fracking looks a lot like a traditional oil well operation where there's a wellhead or a derrick that serves to operate the machinery. And then from there, they drill a vertical well bore down some 50 to 300 feet, depending on where you're trying to get. Now, the real piece of technological innovation that makes fracking unique is when they reach the shale area, they've devised ways to drill horizontally. So they get down to the shale and they make a right-hand turn, and some of these horizontal wellbores can go for over a mile into these shale formations. A lot of people think this horizontal drilling was developed by Montgomery Burns in 1995 or so, but really it is just a product of the energy industry. It was developed in the 60s and 70s in Europe and South America, and then not till fracking has really come into its own has it been widely employed. So once that vertical and then horizontal wellbore is drilled, in essence, they take a slurry of water and chemicals and some other things and pump it down into the wellbore. About 10% of that slurry is sand, so they pump it all down in there, and what happens is that it actually fractures the shale rock. This releases the natural gas that's stored down in there, and mind you, I'm not a geologist. This is all sort of what I've been learning as I've looked into this, but the key to this whole thing is this sand. If sand wasn't part of this slurry that they pump in there, these fractures would just collapse on themselves, and it would be a very short operation. But you get the sand down in there, and it props open these fractures. They call it proppant, and that really enables this whole fracking operation to work. So the sand has to be a very specific type of sand, and Wisconsin has lucked out, sort of won the geologic lottery, and a lot of the best frac sand is actually found in western Wisconsin. In 2014, Wisconsin supplied almost half of the country's frac sand. Now, as energy prices have declined, as petroleum prices have declined, that sand industry that was really growing in Wisconsin during the first decade of the 2000s has hit a bit of a downturn. But I was reading some reports just the other week that said, even though we've seen fracking take a bit of a downturn, we really do think that this is a sustainable industry. So, even if energy prices stay relatively close to where they are, folks think that fracking will survive, and a lot of the sand mining operations in Wisconsin will likely survive as well. And this just shows where all these current sand mining operations in Wisconsin are. At last count, there were 84 of these things going on in the western part of the state. So all that is just background for the first case that we'll talk about today. This is minerals development versus Hunton and Williams. This involves a 300-acre frac sand mine in western Wisconsin, and it was owned by an entity known as Wildcat. So Wildcat entered into a contract with Minerals Development, and it was a supply agreement. Minerals said, here, we're going to buy all of our Ottawa white sand from you, and you, Wildcat, you can't enter into a contract with anyone else to sell this Ottawa white. We're going to be your sole buyer. Then Minerals turns around and enters into an agreement with Superior Silica. Superior is one of the big players in the country in this industry. So what Superior does is they take the sand and they treat it and then load it up onto rail cars and ship it to all the main fracking areas. So you'll see they have depots out in the Dakotas for the Bakken Shale, and then, as we discussed, over in the eastern U.S. and the Marcellus Shale. And there's a lot of fracking going on in Texas, so they have depots there as well. So they're one of the sort of the bigger players in this industry nationwide. So the agreement between Superior and Minerals was an exclusive supply agreement, and Superior was obligated to buy their entire requirements for this Ottawa white sand from Minerals. It was a $4 million deposit to allow Minerals to get up and running, and it was for 530,000 tons of sand. Superior did a pretty good job negotiating the agreement. They had a lot of outs, ways that they could get out of the contract. For example, if Minerals didn't meet a certain milestone related to their infrastructure development, then Superior could terminate. Or if Minerals hadn't demonstrated that they could deliver X tons of sand by X date, then Superior could terminate. These weren't ways that Superior would breach the agreement. It just gave Superior the ability to walk away from the agreement if Minerals wasn't performing as Superior liked. So on August 1st, 2009, this is about 2.5 months after the agreement was first signed between Superior and Minerals, Superior says, yeah, Minerals, you're not living up to it. We're going to terminate, and we'd like $3.7 million of our $4 million back. So in this case, Superior is represented by Hunt and Williams. They're a national law firm. We actually work with Hunt a fair amount on some of the transactions in our practice here. They're just a good, large law firm with offices all over the country. So what Superior did is they had Hunt reach out to Wildcat, and they said, hey, Wildcat, we've heard you may have an agreement restricting your ability to sell us your Ottawa white sand. Well, if you didn't have that agreement, we'd really like to perhaps have an agreement to buy that sand directly from you. And so Wildcat sort of takes that to heart, and they end up terminating their agreement with Minerals. And a little bit later in the month, about 3 weeks after Silica terminated with Minerals, Wildcat and Superior sign an agreement for Wildcat to supply sand directly to Superior. They essentially just caught Minerals directly out of this supply chain. So needless to say, Minerals not real pleased with the whole situation, and there was an arbitration provision in their agreement with Superior, and so they commenced arbitration under that contract. And then they also do something a little bit unusual in that they sue Hunt and Williams, the law firm, in state court. And what they say is that, Hunt, you used strong-arm tactics to convince Wildcat to terminate our agreement. In essence, you, Hunt, you tortiously interfered with the contract that we had with Wildcat. Tortious interference, it's probably one of my top 2 or 3 favorite torts. It's something that comes up a lot. A client or some other party will be discussing a potential action or an aggressive posture with respect to a third party, and you're always thinking, well, are they interfering with some other person's contract rights out there? So it comes up a lot. I've never really had to look at the actual elements of this tort in detail, at least not since law school. But I don't want to get into sort of the Hornbook law here, but it is a little bit interesting. You look at these first 4 points, and they sort of suggest that if a party has got a contract with a third party, or at least just an expectation with a third party, the first 4 points imply that they're immune from having that relationship interfered with. And that just sort of strikes me as not right. This is America. Our whole economic system is built on competition. And so the notion that once someone has even just a prospective relationship with someone, that they're somehow immune from someone else sweeping in and interfering with that it just seems counter to a lot of how our system operates. And so it all comes down to this last prong, this whole justified or privileged prong. And in some cases, a third party is justified or privileged to interfere. And really, depending on where you draw that line about what is justified or privileged, that really allows you to define of whether an action is competition and not problematic, or whether a person has crossed over that line and taken an action that's become a tort. So I went back and I looked at, how would this case come out in Wisconsin? Where does Wisconsin draw this line about what is justified or privileged with respect to competition? And Wisconsin has really followed the restatement of torts. So Wisconsin has really adopted that sort of approach that's taken in that sort of tomb of legal authority. And really the main factor in determining whether an action or an outside party is justified or privileged to interfere, it really depends on whether the plaintiff already has a contract in place with this third party. So if there's not a contract in place, if it's really just a prospective relationship or an expectancy, then the third party is privileged to interfere if they are just competing, if that's what they're doing. Now, the privilege to interfere isn't absolute. There are exceptions that have sort of evolved in case law over the years. So if the action is independently wrongful or independently a tort, or has sort of malicious intent or looks bad or just smells bad, then you start to get into the area where, well, maybe that act isn't protected anymore. Maybe this is independently a tortious interference. even though there's not a contract yet in place. Now, on the other hand, if the plaintiff already has a contract in place with a third party, then the defendant is generally not privileged to interfere with that in connection with competition. Now, again, there are some exceptions to that. If that third party is coming in and they're trying to protect a legal right or proprietary information, they have some independent, justifiable basis for interfering, well, then perhaps that what they're doing is actually defensible, isn't going to be a tort. But for the most part, if there's already a contract in place between the plaintiff and the third party, the interfering with that could push you into the realm of having been committed a tort. So in this case, Minerals and Wildcat, they very clearly had a supply agreement in place. To me, it seems to follow. It seems that Superior and Hutton took an overly aggressive approach when they approached Wildcat and convinced them to terminate that contract with Minerals. The holding of the case doesn't get to this issue, so they end up settling that piece of it. And Superior agreed to pay that $500,000 to Minerals to settle that claim. And the flip side of that was Minerals was supposed to release all their claims against Superior. They were allowed to keep their claim against Hutton. That wasn't part of the release, but in general, that was supposed to be the end of the action against Superior. So Superior pays the $500,000 in cash, and then here's where things start to get a little bit weird. Minerals doesn't release the claims against Superior. In fact, they start adding to the claims in litigation. So that was in 2009 is when this whole started, and in 2010 is when the arbitration was settled, and they bounced around from state court to federal court and then back to this arbitration action. And finally, about 2 years later, Hutton says, this is ridiculous. They motioned the court for sanctions against Minerals and its attorney, and this is in June 2012. Finally, in January of 2013, the state court comes around and says, yeah, enough. We agree. All the objections that Minerals you keep making to keep this thing alive, they're done. We're dismissing your claim with prejudice. You can't refile that anymore. And then in August 13, the court awards Superior sanctions against Minerals and its attorneys for dragging the litigation out so far. So Minerals appeals, and that's how this action ended up in the Court of Appeals. So, from my perspective, there was sort of two things here that I found interesting. One, how is Hutton in this, right? Hutton's a law firm. To me, it was surprising to me that Hutton could be sued and, I guess, kept in this action for this period of time. Obviously, me as an attorney and working at a law firm out there taking actions on behalf of clients every day, does this mean I'm, subject to being sued and dragged into a court like this? What's the law behind that? And then secondly, the whole notion of sanctions. How much of a jerk do you have to be before the court's going to award you sanctions? And I remember reading about sanctions in my civil procedure class back first year of law school, but thankfully, at least in my practice, it hasn't come up since then. So just understanding the groundwork of when you can become when you can become subject to sanction in Wisconsin, I thought was interesting. So as far as Hunt and Williams is concerned, so they have qualified immunity, and this was the ultimate rationale for why they were allowed to be dismissed from the case. And qualified immunity for attorneys in Wisconsin, in general, the general rule is that attorneys are not liable to third parties as long as they're acting within the scope of the attorney-client relationship. Now, there are some exceptions to that. If the attorney is out there committing a fraudulent or malicious act, well, that's something that can take them outside of the qualified immunity exception. Or if they're inducing their client to commit an unlawful act, that's something that's not subject to immunity as well. And the case law is actually pretty specific here about what unlawful means. And unlawful, at least for interpreting qualified immunity, really means inducing your client to run afoul of a court order or a regulation. What it doesn't mean, what's sort of on the other side of the line, is if you induce your client to breach a contract obligation or fiduciary duty, that's something that the court says, okay, that's a little bit different different issue here, and that's something that's not going to expose, that's not going to ruin an attorney's immunity for taking those sorts of actions. There's actually quite a fair amount of case law in Wisconsin about where this line is actually drawn, whether what actions an attorney can take to compromise the qualified immunity. And then, so to get to the sanctions issue, in this case, the court awarded sanctions under Section 802. There are a number of sections in the Wisconsin statute that provide for sanctions against attorneys. From what I understand in civil litigation, this is the section that the court will use to award sanctions in that context. Basic idea is that any time an attorney files something with the court, it's effectively a representation that you're not filing for an improper purpose. So if the court does find that there was an improper purpose behind the filing, then they can sanction the attorneys, they can sanction the client, they can sanction both of them. And the penalties are not just limited to cash. It can impact the bar admission of the attorneys as well. The court has a wide range of different types of sanctions that they can use. So in this case, the court sort of runs through a laundry list of what they saw as the improper purpose and why they were willing to award sanctions against Minerals and its attorney. Now, the first was you were really just pursuing this action against Hunt to ratchet up the pressure on Superior. You're trying to get them to settle the main issue in arbitration, and to sort of pile on, you filed this lawsuit against them. And then one other prong is sort of a bad faith. You got this $500,000 and you kept it. Meanwhile, you just kept going in the litigation. You didn't really see the logic in that. And then there's a bit of a sort of a gross negligence prong. Hunt had obviously qualified immunity. You should have known that, yet you pursued this baseless action against Hunt as well. And then on just sort of a common sense prong as well, that you knew this was a losing action, yet you just kept driving forward as well. So after all that, the court upholds the sanctions. What they ended up doing was they sort of looked back in time about 13 months and found a point in time that said, you Minerals and your law firm, you should have known at that date that this action was dead. And so for the 13 months after that, while you kept pursuing this action, we're going to award all the legal fees incurred by Superior and Hunt. We're going to award those as sanctions. And they also took some actions against the bar admissions of some of the attorneys as well. So that's the Wisconsin case from about a year and a half ago. Any questions from a robust audience? All right, so the next two cases are a couple Delaware cases. Both of these were written about in blogs and such things rather extensively this year. The first one involves Prairie Capital. Prairie Capital is a middle market private equity group based out of Chicago. And it involves their portfolio company, Double E Company. This is, I looked at what does Double E Company do, a very generic name. Well, they pride themselves on making accessories for web process manufacturing. I had no idea what web process manufacturing is. Does anybody out there know what web process manufacturing is? I didn't think so. So what web process manufacturing is, apparently, is things that have to do with these giant rolls of paper or cloth. And what Double E Company does is make these chucks that insert into these rolls, and they handle an incredibly large amount of weight and spin at an incredibly fast rate. And so they need to be very finely manufactured products. So that's what Double E makes. Now their signature product is this extreme core chuck. Suggests that their research and development is a bunch of snowboarders hopped up on Mountain Dew, but they are one of the leaders apparently in this area. So 2011, Prairie has owned the company now for I think 5 or 6 years, and they decide that it's time to sell. So they hire an investment banking firm and they conduct an auction to sell EE. They go through the auction process, and in February 2012, Incline Equity Partners, another private equity group, sort of emerges as the winning bidder, and Prairie Capital agrees to go exclusive with Incline for a period of, I believe, 60 days. Incline offered $27 million as their sort of winning bid. They initially were at a little bit over $26 million, but the banker in the deal went back to them and said, hey, don't you think he can really, let's see what you can do here. Get your bid up to 27. There's some other people competing. We think if you give 27, you can probably win. Incline was a little bit reluctant to do it. They had not been overly impressed with some of the revenue figures that they had seen coming out of the company, but nevertheless, they came through with a $27 million bid. But they said, okay, what we really want to do is see how your next couple months of sales stack up, and if you hit the goals that you say you're going to hit, great, we're willing to close on $27 million. But they made it pretty clear from the outset that their $27 million price was contingent on hitting those goals. And everyone targeted the end of March 2012 for closing. So at the beginning of March 2012, Incline gets the February numbers, and they look a little soft. And they're like, guys, we're really not interested in, we're losing interest here because revenue is just not stacking up to where we want it to be. That said, you've set a good goal for March 2012. If you can hit that $3.2 million of March 2012 sales, we'll close. So everyone's watching very closely what's going on in March 2012. Well, halfway through the month, they're only at $500,000 of sales, and Prairie's starting to get a little bit nervous. March 19th, they're up to 1.1, still far short of the 3.2, and they're getting increasingly nervous. March 23rd rolls around, and they realize that they've got a problem. And so the two principals at Prairie Capital, they sort of huddle with the CEO and the CFO at EE, and they say, okay, we've got a big problem here. What are we going to do? And what they decide to do, and this all comes out later, is they say, okay, well, in the next week for the end of March, we've got about $1.1 million of sales that we know are going to occur. And then in the first week of April, well, we've got about $650,000 or so of additional sales that we know are going to occur. Why don't we just take those $650,000 of sales from April and let's just move them into March? And so they ended up fabricating invoices and really changing the internal accounting records to make it appear as if the revenue that was going to be recognized in April had in fact been recognized in March. Their thinking was that the CEO and the CFO, they're going to remain in their positions post-closing, right? They're not going to change. They're selling to a new private equity group who's not going to at least immediately change senior management, and so they'll be able to sort of smooth over the books, and no one's really going to notice that the revenue numbers moved around quite a bit. So at the end of March, Prairie comes back to Incline and says, hey, yep, we did it, $3.2 million, we hit our goal. And Incline says, okay, fine, transaction closes at the $27 million number. So about 14 or 15 months later, right as the escrow is about to disperse, Incline starts submitting claims against Prairie and the sellers, and the basis of the claim is, hey, there were $650,000 of false shipments in your March 2012 revenue numbers. And they assert claims sort of along two different avenues. One, they've got a stock purchase agreement, and the purchase agreement has indemnification provisions that basically say the sellers will make the buyer whole from any breaches of reps or other specific matters that are covered by the stock purchase agreement. And so Incline asserts those claims, certain claims under the indemnification provisions of the SBA. But they also assert fraud claims, and the fraud claims are based both on the reps and warranties in the SPA, but also on extra contractual statements as well. Now the fraud claims are a little bit more important, and they seem to be duplicative at first, right? So the indemnification claims on the SBA says the seller is going to make the buyer whole. So why do you need to also assert these fraud claims as well? Well, the way a lot of these purchase agreements are set up, there are a number of provisions in the purchase agreement that are intended to protect the sellers. There are caps on the seller's aggregate liability, there's baskets, there's damages limitations, and frequently one of the main carve-outs from those protections says that if the buyer can prove that there was a fraud claim, all those exceptions go away. And so Incline asserts fraud claims here in an attempt to basically go around all the seller protection provisions that are in the stock purchase agreement. So I don't want to get into the elements of fraud. I think most people listening should be pretty familiar with that, but the first prong here, the first element, is that you need to have a false representation to have a fraud. Without that, without a false representation, there's just no way of proving a fraud. And so in this case, as I mentioned, there were two types of quote-unquote representations. So in the stock purchase agreement, there's an entire section of representations and warranties that the sellers make to the buyer. Just as an example of how one of these works, this is a sort of a sample representation from a purchase agreement, and in this, the seller's warranting to the buyer that the financial information for a certain period that we gave you is correct. That's one of the warranties we're going to give you. Now there's also extra contractual representations, and these go above and outside what's actually warranted in the SPA. And these can take any of a number of different forms. They can be verbal statements. They can also be less formal writings. For example, in this case, in the Prairie Capital case, the March 2012 financial results weren't covered by the financial statement rep in the purchase agreement. So when Prairie comes back and says, here's our March 2012 revenue number, well, that wasn't something that they were warranting to in the purchase agreement. It was a sort of an extra contractual rep. They were making a representation, yeah, we're giving these numbers to you and they're correct, but it's not something that was explicitly covered by the purchase agreement. And Incline in this case asserts fraud claims based both on the express representations in the SPA and then also on the extra contractual representations that were not in the SPA. And so the court takes a really close look at how the purchase agreement was worded in this case, and they come to the conclusion that Incline, to the extent that your fraud claim is premised on extra contractual reps outside the SPA, you don't have a claim here. And what they did was they looked at what's known as the exclusive representations clause in the document. And this is a very sort of formalistic interpretation of these provisions, but in many cases these purchase agreements have a clause that says, other than the reps and warranties in the agreement, there's no other reps and warranty. And the general intent of that clause is to exclude exclusive or non-contractual representations. Now the court looks at that provision and says, in this case, that statement was from the buyer's perspective. It was the buyer acknowledging that we're only relying on the representations in the purchase agreement and we're not relying on anything outside of that. And because the buyer, that was a statement made by the buyer, we're going to preclude them from relying on anything outside the SPA. And the court also roped in it also helps that they have this standard sort of integration clause. There's no other documents. But the real, I guess the real interesting piece here is the court's interpretation of the exclusive representations clause and the impact that had. So yeah, the key point here is that this must be from a statement from the perspective of the buyer. So there was another case about 6 months later, almost the same exact issue, and this was Mason Wells, is a local private equity group here in Milwaukee, and they were the buyer in this case. And in that case, there was an exclusive representations clause in the purchase agreement as well. Now the difference was in that case, the clause was given from the seller's perspective. And so in that case, the court allowed Mason Wells to continue their fraud claim based on the extra contractual reps because the disclaimer was given from the perspective of the seller. It's a very minor difference, but it made all the difference in these cases. And so, you know, in that case, there was a $1 million deductible and a $20 million cap, and Mason Wells was allowed to pursue their fraud claim without, you know, and potentially recover outside of these limits. So takeaways here, you know, the way Delaware law is now, these types of disclaimers have to come from the buyer to be given effect. The court says, you know, there's no magic words. It's really just got to be a statement by the buyer that they're not relying on anything, but non-reliance, I think, really has to be an element to that. So I really do think that there is at least one magic word, but there's not a specific type of formulation that this has to use. You know, when we do this now, not only do you try to tie in non-reliance to, you know, non-contractual representations, you really try to tie in any other pieces of information that the buyer could have in their possession, things they've pulled out of data rooms, things they've seen in the confidential information memorandum. Just try to make it as broad as possible to cut off any potential fraud claim based on those items. And it's sort of given you know, a sort of an offshoot here is how is fraud interpreted? Because of, you know, these cases in part, and if you do have a successful fraud claim, it really is a very powerful tool from the buyer's perspective. It's in the seller's interest to define fraud as narrowly as possible. And fraud is subject to a lot of different interpretations. There obviously is actual intentional fraud, but there's also, you know, sort of equitable fraud. The court says, well, even though there wasn't the actual intent to fraud, what occurred was so egregious that it was effectively fraud. And there's other, you know, sort of similar fraud-like claims as well. You know, what we've started doing on the sell side is really trying to define fraud as narrowly as possible. I don't want to read through this, but the basic idea here is, at least on the sell side, you want fraud to mean an actual and intentional act. Somebody was really trying to get away with something. And these two cases, Prairie Capital and then the Mason Well case, were both in the M&A context. I haven't seen any cases that have applied this to outside M&A, but some other purchase or sale transaction. But presumably the same logic would apply, at least under Delaware law, to a transaction between sophisticated parties where someone is buying something and there's warranties being made. So potentially this could have application beyond the M&A context. And then the third case is Sega Tech. So this involves smallpox. I knew very little about smallpox. Last I really recall was when I was a kid watching, I think, Little House on the Prairie, and there was a smallpox wave that wiped out Ma and Pa or something. But in any event, smallpox used to be a you know, a very problematic disease. It was a sort of a horrible part of scourge on humanity. 20th century, there were about 300 to 500 million deaths, and you know, for this 20 to 60% mortality rate, even those who survive end up with horrible scars. It's just a very, you know, it's just a horrible disease. Ultimately, it was eradicated in 1979. Now it's still around. There's still stockpiles of this stuff to be used potentially in biological warfare, which is troubling to say the least. So SIGA, they ended up with an antiviral drug designed to protect against smallpox. The way that their drug works, it would find the cells where smallpox was inhabiting, and then it would prevent the virus from leaving the cell, preventing the virus from going viral. Ultimately, SIGA was ended up with a contract with the Project BioShield Act. I think a sort of a pseudo-government supported organization that stockpiles viruses for potential use against biological warfare. And in the 2011 contract with Project BioShield, it was basically a $460 million contract, options to purchase more for 2 million courses to put in the strategic stockpile. So 2011 is when they ultimately entered into that contract. We have to look back in time a little bit to see how this all developed. So 2004, SIGA acquires the rights to this antiviral drug. It's not actually clear, at least clear to me, where they got it from, but SIGA ends up with the rights. In 2005, they sort of take stock of their situation and they say, well, we have no money and we have no idea how to sort of monetize this asset. All we really have is this asset and we don't really know what our next steps are. So they approach a company called PharmAthene, and PharmAthene had money and had expertise in taking these drugs to market, and they entered into a non-binding term sheet with PharmAthene. Basically, PharmAthene would be entitled to economic incentives to help SIGA monetize their antiviral drug here. So, as things progress, SIGA and PharmAthene in 2006, they say, okay, we've got this non-binding term sheet. PharmAthene's going to try to potentially help us. Why don't we just merge? Maybe that's better off for everybody. The SIGA stockholders can get some PharmAthene stock. We'll all just proceed together as one big happy family. As they're discussing the merger in March 2006, PharmAthene, they provide a $3 million bridge loan to SIGA to keep SIGA afloat while they're still talking about the merger. Now, what's important to note is that this loan agreement, this was the first binding agreement that these two companies had entered into, at least that's relevant to this case. And there's a provision in this loan agreement that says, all right, if this merger term sheet that we've been discussing, if this goes away, and if this whole merger goes away, well, SIGA and PharmAthene, you'll use good faith to negotiate a license agreement that reflects the terms of this non-binding term sheet that we entered into in 2006. And so that's baked into this loan agreement. So, SIGA gets their $3 million bucks, and then things start to look up. They get a grant from a health agency. They have some successful human trials. They get some feedback from the CDC that says, yeah, their drug is actually legit. They do a little bit of math, and they start to say, hey, we've really got something here. We may potentially be worth $3 to $5 billion if this all plays out as it looks like it's going. There's even an email that comes up from the chief scientific officer of SIGA that basically says, do we really need PharmAthene anymore? We really could have done this all on our own. So SIGA's board decides to terminate the merger discussions with PharmAthene. I think we could probably have a go at this on our own. And in 2006, now remember, they've got this provision in the loan agreement that says if the merger discussions go away, well, they've got to negotiate in good faith to sign that license agreement reflecting those terms. So PharmAthene says, okay, merger's done. We'd like you to sign our license agreement. Here's a draft. It reflects all the terms. Let's sign it up. And SIGA says, nope, sorry. If you guys want to discuss some additional terms, we're happy to do it. But the terms that you put in that agreement, we're not interested in those anymore. So PharmAthene sues. So the issue here was, well, there's really two things. The first is that they baked this is really a preliminary agreement. These terms in this non-binding term sheet were a preliminary agreement, but they had ended up in a binding document in that loan agreement. And so the court found that even though that was a preliminary agreement, there was an actual binding agreement to negotiate in good faith to come to an actual license agreement reflecting those terms. So typically and historically, when there had been a preliminary agreement like that that was binding, the court said, well, you're only entitled to reliance damages. It was really preliminary. It wasn't a fully baked contract. You're not entitled to the full benefit of your bargain, but if you did expend some resources in reliance on that, okay, the aggrieved party is allowed to recover those reliance damages. Well, Delaware Supreme Court really changes course here, and they say, no, in this case, the the terms were definite enough in your preliminary agreement that we're going to say, yeah, you, PharmAthene, you're entitled to your expectation damages. You're entitled to the full benefit of your bargain that you would have received had you entered into that license agreement with those terms. So ultimately, PharmAthene ends up with a $113 million damages award. So I guess there's a number of takeaways from this case. One thing is how to handle agreements to negotiate in good faith, and really sort of a cautionary tale about agreements to negotiate in good faith. Usually, people use that sort of construction when you're just kicking the can down the road. We've got an agreement to move forward except for this one issue. Well, let's just say we're going to negotiate in good faith on that issue in the future. This case is a good reminder that those agreements to negotiate are binding. It's not something to be taken lightly and just glossed over. Delaware now is an outlier with their expectation damages in this sort of scenario. I don't really think this is a reason to pick a governing law outside of Delaware, but if you are in Delaware and have an agreement with this type of language in it, just be aware that Delaware, unlike a lot of other states, is willing to award expectation damages if those terms are concrete enough in the preliminary agreement. And then think about binding agreements versus non-binding agreements. The key here is that those non-binding terms ended up getting baked into a binding agreement. So if you're working with something that's intended to be non-binding, make sure that it's very clear how it's drafted that that is in fact non-binding. I don't think the court would have come to the same conclusion here if this was all a non-binding agreement. And SIGA didn't really help itself. All they had was an obligation to negotiate in good faith, and they didn't even take the first step towards fulfilling that obligation. It was just straight willful repudiation from the start. So if they had negotiated in good faith, even if they hadn't come to a license agreement, the court probably wouldn't have come to the same conclusion here. The fact that there was so much willful behavior on their part, I think, really gave the court a lot of support for the outcome here. So what happened after this is just sort of interesting. So SIGA was a public company and was filing 10Ks and 10Qs. So you could sort of follow along as this was progressing. And so in 2014, I filed for Chapter 11 bankruptcy. Along this time, the case is still bouncing between Chancery Court and Supreme Court, and ultimately the Supreme Court affirms a $205 million award, which was the last sort of word on what the damages were in this case. And so then that ends up back in the bankruptcy court, and they end up approving a plan of reorganization that essentially says, all right, SIGA, you either pay PharmAthene in full for your full $205 million, or PharmAthene just ends up getting all your shares. So that's really what they've been working with over the past year. Last I looked at it was in March of this year, and SIGA had about $104 million of cash that they either had on hand or had paid towards that judgment, but it wasn't clear whether they were going to get up to that $205 million mark. That was sort of the last word on it. Any questions? Yeah.
In the current case, you're saying about the disclaimers by the buyer or seller. What does that mean? That we drafted the purchase agreement?
It's which section of the reps, I guess you could say. So in these purchase agreements, there's a whole section of the seller's reps, and there's a section of the buyer's reps as well. And so in this case, the disclaimer was at the tail end of the buyer's reps, and it said the buyer reps and warrants that it acknowledges that it hasn't relied on anything else, and that's what they found as the determining factor. That was in the buyer section of the agreement. Pretty technical, but that's the state of the law. Anybody else? Come on, Al, you got to have something for me here. Who did I vote for? Well, I don't know if we really want to get into that. It's that's right. All right. Thank you, everybody.